Hello and welcome to the big picture. The landmark judgment of the Supreme Court yesterday, declaring the provision under the Representation of People's Act, which protected sitting MPs, MLAs and MLCs from losing their seats despite being convicted as ultra-wires, is being seen as a very significant step towards cleansing the politics of criminal and corrupt elements. The issue of criminalization of politics has been a matter of very serious concern in the recent years, with more and more people with criminal records or cases against them entering the legislatures and parliament. This landmark verdict is expected to curb those tendencies, especially with elected members losing their seats as soon as they are convicted for any offence with sentence of over 2 years. However, there are some concerns being expressed already about the impact of this verdict. One is the level of empowerment of the lower level judiciary with this verdict. The lower level judiciary, as we all know, has not acquitted itself as well as it should have, and we have all seen a lot of cases where manipulations have taken place. On the other hand, this verdict is also an opportunity for the political parties which have sometimes found itself helpless under the pressure of the criminalized and corrupt elements demanding tickets. Today we will look at the impact of this judgment and whether it would cleanse Indian politics or open up new and more sticky issues. To discuss this, I have a power-packed panel of guests, Prakash Javadekar, the BJP MP and also its spokesperson, Mr. Dushyant, a well-known senior advocate in the Supreme Court, and Professor Jagdeep Chokkar, founder member of the Association of Democratic Reforms, which has done significant work in the area of electoral reforms. Others will be joining us.
The big message is that we infirmities, if it all they have, still I will welcome it because this it is not only charge sheeted.
Absolutely.
It is not only frame charges. It is debate the issue in the court and court hears both the sides and then comes to a decision and then he ceases to be member. And still he retains the right to appeal as any citizen has the right to appeal.
Yes, but you know, Mr. Javadekar, you very well know, and I'm sure you will have no problem admitting this, that this is not a problem confined to one party or two parties. This is a problem which has been faced by every political party, which is party. You think that this will be some kind of a tool in the hands of the political leadership of political parties to avoid giving tickets to these kind of people now?
Yeah, this is definitely one stimulant which has come into operation, but ultimately how it spreads like infection. That contesting election, of course, winnability becomes a very prime thing.
Yes.
And when winnability prime thing, and if somebody is putting up a Bahubali from their party, then other party also try to think that to compete him, goes on.
Yes.
And that's why this spreads.
Yes.
But at the same time, let me also tell, even we launch an agitation against the price rise, we are booked under criminal procedure code. That is when somebody watch. So that has to be differentiated.
No, I understand.
Not like the last 30 years we are fighting one after another cases.
Okay. So you
but
also...
These are moral turpitude case, no way.
Okay. Two more people. Mr. Shankar Aiyar, a Congress MP in the Rajya Sabha, but you know, somebody who understands the rough and tumble of electoral politics also. I'm in the coming.
Well, I'm glad it's come. Because
yes.
Now, what the judgment says is that merely being accused of being a criminal doesn't amount to becoming a criminal. It is only when a conviction takes place, and convictions take place or don't take place only on the basis of facts,
right,
as ascertained by the court.
Right.
After that, the appeals process is a process of whether the law has been properly applied or not. Not a question of fact, it's a question of law. But your being convicted of being a criminal makes you unfit for public office. But you still have the possibility of returning to public office if on a point of law, a higher court, such as the High Court or the Supreme Court, were to overturn the verdict of the lower court.
But Mr.
So I think it's an excellent example of a good law both from the point of view of those who are charged with this and those who are not. And from what I'm able to make out in the newspapers, where ludicrous remarks are made about hundreds of criminals being in Parliament, we now find that maybe 3 or 4 members of Parliament now or in the immediate past are perhaps going to be affected.
We
but not, of course, now in a prospective sense.
Yes, Mr. Aiyar, but one issue which I want to flag here is that this order, this verdict to the Supreme Court clearly establishes that all these years the elected representatives had been getting this kind of a protection which they didn't deserve.
Well, whenever a judgment comes, it does mean that what went before, which was also within the cognizance of the institutions of the state, including the court, were not as right as they ought to be. But when you compare the kind of campaign that is conducted by civil society or in the media, that the place is filled with criminals, the court has said that this is rubbish. Our parliament is not filled with criminals. There may be 3 or 4 people in today's Lok Sabha and Rajya Sabha who could have been affected if this law had been there earlier.
We will
come compared to the argument that 170 people, 180 people are criminals,
we will
it's
get
clear
that,
this
we will
has
get those numbers.
the situation.
We will get those numbers, Mr. Aiyar, as we go on. But the fact of the matter is the Supreme Court has not said what you think. They said that, the Parliament is not full. They have not dealt with that issue at all. Let me go to Mr. Quraishi. Mr. Quraishi, this was one area which you also, when you were in the Election Commission, had been campaigning for quite some time. The Election Commission of India has been talking about it, writing about it, requesting to look at this. Do you think that this order finally puts some kind of a closure to that problem which you people were facing or raising?
Actually, we were talking about something else.
Something more.
We were saying that the people who are accused of heinous offences,
right,
and even before conviction, they should be debarred from contesting.
Right.
In this case, this is about those who have already been convicted.
Already convicted.
And even after conviction,
yes,
you get disqualified from contesting.
Right.
But that conviction and the impact of conviction was getting suspended under the Representation of People Act, which was infringing the Constitution.
Right.
So this is only about those who have been convicted.
So you're you are not fully satisfied with this. There are still other issues which needs to be dealt with, you think?
No. Why should we think negatively? We are very satisfied. At least one principle has been resolved. There was another discrimination that if you were in jail, you could not vote, but you
right,
could contest.
Right.
Even that discrimination has also been ended. So, but that's a different issue. We are satisfied with this, but the other wider issue of serious cases, heinous offences pending, which will carry sentence of 5 years or more, rape, dacoity, murder, kidnapping. Now imagine the people accused of such serious crime against whom the charge sheet has been framed, they continue to be in power. So that is what we have been fighting against, and I think that is probably the
separate
next
issue.
Logical step.
Right. Yeah. Both the politicians on the panel, Mr. Javadekar and Mr. Shankar Aiyar, have expressed some kind of relief that has not been taken up at so far. But let me come to Mr. Dushyant Dave. Mr. Dave, you think that this order of the Supreme Court is something which is the best thing that could have happened, or you think that there are still some infirmities in this order?
Let me put it this way, that the conclusion of the court is right, but its reasoning is extremely faulty, unfortunately, for the simple reason that the judges have said that the Section 8(4) of the Representation of People Act is ultra vires constitutional provisions of Article 102 and 191.
Right.
Now, frankly, judges should have really seen Article 101 and 190, because both these provisions in respect of members of parliament and members of the legislative assemblies expressly provide that if a member attracts disqualification under a law framed by the parliament, which is Section 8(1), then his seat shall become thereupon vacant.
Right.
Now, therefore, this disqualification and vacation of seat is automatic as per the founding fathers. And frankly, Section 8.4 runs absolutely counter to that. So that's something which judges have, really missed in their judgment. Judges have also said in the judgment, which I think perhaps wrongly, that the source of power of framing Representation of People Act is derived from Section 102, Article 102 and 191, which is not correct, because all source of power comes only under Article 246, and therefore to that extent there is some lacuna in the judgment. But having said that, I must say that the conclusion is absolutely inescapable. Section 8.4 of the Representation of People Act is absolutely ultra vires, it's totally arbitrary. Because if you are going to allow people who stand convicted by a competent court of law, then it makes mockery of the very provision which the founding fathers have provided in Articles 101 and 190. For example, take the presidential power. President has been given power under Representation of People Act to decide on a representation when it comes to corrupt practice.
Right.
Or for that matter, chairman of the House or the Speaker under the 10th schedule, he has a power to decide disqualification.
Right.
Now, if you are going to say that once president or chairman or a speaker have taken a decision and yet they don't stand disqualified, then it makes mockery of the very provisions.
I think you have a very important point there, because those were contradictory, because what the speaker and the chairman can do stands the test of time, but what a court, lower level judiciary has
A competent court.
A competent court.
Don't call it lower judiciary.
Okay, a competent court, if I have to go by you. But but it's interesting that you're accepting the larger issue which has come out of this judgment, but you seem to have some other legal issues involved. But we'll come to that. I want to go to Mr. Jagdeep Chokkar.
Which I am afraid political parties will use.
Will use. Okay. How do you think they'll use it?
By filing a review petition in Supreme Court.
That seems to be the mood now. We'll wait and watch what we'll do. But
Just
we'll
one
come.
minute.
And I am afraid they might succeed.
Just 1 minute.
Yes, Javadekar. Yes, Mr. Javadekar.
Yeah, I think that is why I demand that Law Minister was yesterday not very clear, coming clear on this. So I request that government should not file a review petition.
Should not.
Yes.
You don't think a review petition should be filed?
We should not, and government should not. If somebody is disqualified and he files, that's a different thing.
Right.
But you
That's
don't
interesting.
do it.
That's
That send a good message.
That's interesting. Mr. Shankar Aiyar, do you also agree with Mr. Javadekar that no review petition should be filed by the government on this verdict?
I would hope that the government won't file a review petition unless our law officers come to the conclusion that if Mr. Dave is right, that the reasoning is flawed in law and therefore a conclusion cannot be sustained. What I would like to see is the conclusion of the court being sustained.
Exactly.
And unless there is the danger that the argument put forward by Mr. Dave will lead to the invalidation of the conclusion, in which case I think we should file a review.
Okay.
But otherwise, no. I think in substance, the judgment is very balanced because it rejects the idea that a person charged with a crime should be assumed guilty, not innocent.
Absolutely.
And at the same time, it also says that the abuse of the legal process by allowing the appeals process to go on indefinitely after conviction should not become a basis on which a convicted person is sitting in parliament.
Absolutely.
It's a very balanced judgment and one I think that should be sustained in its conclusion. But if a review is required because the legal reasoning is long and I'm not competent to judge whether the legal reasoning is right or wrong, then maybe there's scope for a review petition.
We'll put that issue aside and see how it develops in the coming days. But let me go to Professor Jagdeep Chokkar. Professor Chokkar, your Association of Democratic Reforms has been campaigning for electoral reform for a long time. You think this is one of the significant steps? And one second thing is this, the argument of Mr. Shankar Aiyar that this judgment has cleared some of the politicians, that all of them are not criminals. Do you think that is what comes out of this judgment?
Well, the judgment is definitely a positive and significantly positive step towards cleansing the political and electoral processes of the impacts of criminalization which were first brought forth by the Vora Committee report.
Yes. Yes, yes, please.
Obviously, if there are 162 members in Lok Sabha who have declared on sworn affidavits that there are criminal cases pending against them in which they can be convicted of imprisonment of 2 years or more,
Right.
it obviously means that the balance of the MPs are not so.
Mr. Chokkar, Mr.
But
Chokkar, Mr.
an
Chokkar, I want,
analysis of
Mr. Chokkar,
more than 4,000.
Mr. Chokkar, please, I want a clarification here. Are you saying that 162 MPs
Yes.
in the Lok Sabha today who have filed affidavits saying that they have criminal cases against them, or all these cases are those cases which can be given more than 2 years imprisonment? Is that what you are saying?
Yes, that is the Supreme Court's order of 2003.
No, I'm
that
talking about
only
the one.
cases in which the punishment is 2 years or imprisonment or more should be reported.
Okay. So
That is the Supreme Court
No, but-
judgment, and that is what is reported in the affidavits.
no, but I have read you people have only segregated it between serious cases and non-serious cases. What does it mean? There are
Well,
some 75
serious-
MPs
we
who
have
have
not
serious.
segregated between serious and non-serious. We have segregated between criminal cases and cases of heinous crimes.
Okay.
Heinous crimes are crimes like murder, rape, abduction, dacoity and so on.
And that
But
number
there
is
are also any number of criminal cases in which the punishment is imprisonment of 2 years or more.
so, and that number with very serious cases are about 75 or so.
No, you see the point, Mr. Anchor, is the heinous crimes are different from normal crimes.
I'm not
A
denying
murder
that, or I'm
case
not questioning
requires a
that.
punishment of life imprisonment.
I am not denying that, sir. I'm asking you a clarification. The heinous crimes, people who have reported heinous crimes, the number is about 75.
That is correct.
Okay.
Heinous crimes is about 75.
Okay.
But criminal cases in which the punishment is more than 2 years or 2 years and in which charges have been framed,
Right.
that number is 162.
Okay, Mr. Okay, let me come to Mr. Quraishi.
Let us not dilute this number.
No, we are not diluting. I am not diluting the number. Mr. Quraishi.
You ask Quraishi.
Mr. Quraishi, this differentiation between the serious crimes and heinous crimes, the differentiation, is this something which is sustainable? One. Second thing is, when you were the CEC, Chief Election Commissioner also, you just now said about all charge-sheeted persons should be kept out of electoral process. Is that the next step you think the judiciary should look at?
Yes. I feel concerned that this debate is getting confused between
Yes.
two issues. There is a question of cases pending before conviction,
Right.
and what happens after conviction.
Absolutely.
This recent judgment which we are debating is about
After
what happens
conviction.
to the convicted.
Absolutely.
Now, let me also tell you, when we are talking, now the next issue we will take later, and this has also been debated ad infinitum. But in this case, what happens is, once somebody has been convicted, even if he goes in appeal, either the sentence is suspended or stayed,
conviction is
or
suspended.
the conviction itself is stayed.
Right.
When the conviction is not suspended, but only sentence is suspended, then the person gets a decision. Then he cannot contest.
You are talking
Well,
of
for
section
instance, you have
380.
Mr. Sidhu's case.
Exactly. You are talking, the Supreme Court in
Yes,
its order
now,
has
for instance,
mentioned this.
our MP Mr. Sidhu, in
Yes.
his case, yes.
You are talking of 389 of Criminal Procedure Code, under which these people can go and get a stay on the conviction. I'm sure I want Mr. Dushyant Dave to come in here. Mr. Dave, is this section 389 protection under section 389 for any convicted members of parliament or MLAs, if they get convicted, they can go to the higher court and say that, okay, under this, please stay my conviction, and if it is found worthy, it will be stayed. You think that is enough protection now?
Absolutely. In fact, the Supreme Court in this judgment has also recorded that.
Right.
Because once the sentence is suspended,
Yes.
then the conviction itself gets suspended. So I think there is no difficulty at all in a given case if a member of the House or Parliament feels that he has been wrongly convicted, and if he can pursue at the appellate court, the Sessions Court or the High Court or Supreme Court in a given case, that the conviction is completely unsustainable, and the court is persuaded to grant suspension under section 389 of the Criminal Procedure Code, then I think he can continue. There is no disqualification then.
Okay. Now I want to come to another issue which has come up because of this judgment. Shankar Aiyar, I want your reaction on this. If now this means that one of the concerns being expressed is that this gives the lower judiciary or as Mr. Dushyant Dave says, the competent court, enormous powers, and then we have seen the kind of manipulation which happens at the lower level of the judiciary. You think that is a cause for concern?
It's a cause for concern, but not only in this context. To my mind, the biggest cause for concern is how much time it takes for an appeal process to be disposed of.
Exactly, yes.
It's also a matter of deep concern as to how long the trial process takes.
Right.
Our judiciary is not a functional judiciary. It has several dysfunctional features, but that can also be said of the executive as well as of the legislative. I'm sitting in a legislature which has not been allowed to function by the opposition for the last 3 years, at least. So therefore, let's not try and set ourselves above the society and the polity in which we live. The fact of the matter is that politicians, like other citizens of this country, are assumed to be innocent until proved guilty.
Right.
And the first conviction, unless it's subsequently set aside, constitutes a finding by a competent authority that you are not innocent, you are guilty.
Right.
And at that point, to ask him to not continue to occupy a public office or stand for one is a perfectly reasonable conclusion.
Okay.
But the idea that you can go on defaming a community by saying that they have been charged with, or that charges
Okay.
have been framed against them for heinous crimes or non-heinous crimes,
Okay.
and that therefore
Mr.
they should be called criminals. It is that
Okay.
kind of language which has been put into perspective by this judgment, and I congratulate the Supreme Court on making
Mr.
this
Javadekar,
clarification.
Mr. Javadekar, quickly, do you think that we need to be concerned about the powers now which will be enjoyed by the competent courts or lower judiciary?
See, when something good has happened, let us see how it is implemented.
Okay.
If something goes very drastically wrong, definitely we have always a capacity to rethink and review.
Okay.
But let us not bring all the things today
Okay.
on the table. It is the judgment which is all good. The spirit is good. Let us see how it operates.
Mr. Quraishi, are there any concerns about the impact of it on the lower judiciary and how they will function, and the worries about manipulation which some people are talking about already?
Yes, the concern is that the competent court is at the lowest level, will have enormous power, and the future of a politician can be in the hands of that judge.
Right.
And therefore, we only hope that those competent judges will exercise their power very judicially.
Okay. Mr. Dave, last words to you.
Yeah,
on this issue.
Let me first and foremost say that I strongly object to your using the expression manipulation in lower judiciary. It doesn't happen that. In fact,
We have read enough. We have read enough.
I have been a lawyer for 35 years, and I can tell you it's not so bad. Secondly, let me say one thing. It's the parliament which has given power to the competent courts under the Representation of People Act to decide upon the guilt of a particular member. So I don't think anybody can question that power. And once a competent court decides it, I think in fact the candidates or the members take every opportunity, abuse every process in a judicial process to delay the conviction. So I don't think we should really be worried about it.
No,
It's
that is
yes,
exactly the point, Mr. Dave. Abuse of the process. How
by the
abuse of the process
members,
doesn't
not
abuse
by
of the
the
process is a two-way
opponents.
process. It is not a one-way process.
It is those who are charged, who are facing a charge, delay the process as much as they can. And that's something worrisome. I agree there.
Okay, Mr. Chokkar, do you have, are you worried about this?
I think the judgment. No, I am not worried about this at all, because as Mr. Dave rightly says, the power of the competent court is given by the parliament itself.
Right,
They draw this power from the constitution and the parliament.
right.
When that power is used on a regular citizen, there is no concern. But when this power applies to a politician or an elected person, there is huge concern. It is the same issue that when the Right to Information Act is applied to hundreds and thousands of public authorities, there is no problem. But when you try and apply it to political parties, then there are attempts made to amend the Representation of
Absolutely.
People Act.
I think,
Political parties and politicians
Cannot-
are also as much under the law of the land as anybody else.
absolutely. Yes, okay,
So
I
if
think.
a competent court at the district level can convict a citizen, it can also convict a politician.
Absolutely. Okay. On that note, I think we'll need to end. But this order of the Supreme Court, this verdict of the Supreme Court is obviously going to have long-term implications, but hopefully for the best of this country and also to cleanse the electoral process in this country. Thanks to all my guests, Mr. Shankar, Aiyar, Mr. Prakash, Javadekar, Mr. S.Y. Quraishi, Dushyant Dave and Professor Jagdeep Chokkar. Please keep watching. We'll come back with another issue in the big picture, same time tomorrow.